Good evening, everyone, and welcome to tonight's webinar on a wet Toronto evening. Please be reminded that this session is being recorded, and as we approach the final few days left in October and before we enter the month of November, which is Make a Will Month in Canada. It reminds me of last year at this time. I had hosted a webinar titled Where There Is a Will, There Is a Way with Leslie Donsky, who is joining us again tonight. And it's fitting that we have her back with us again to continue on where we left off. And for those of you who did not see that session live, I do encourage you to watch the recording from our library, which is on the website page that you RSVP'd for tonight. During that session, she shared lots of great information, as she will again tonight. And we also wanted to equip Canadians and you not just with information, but with a practical next step towards getting over that hump and getting your wills done. And we thought about the idea of, at first, bringing a lawyer to live in your living room for a month until you got your wills done. But our legal team pushed back. They said that that could result in some lawsuits. So the next best thing was to show you how to do a will online. And here we are. Now, as always, I try to keep the agenda as concise as possible. And we're going to start off with Leslie just giving us a bit of a high-level overview on, the rationale, the reason for Make a Will Month, estate planning, what it is, why is it important, and then we'll hand it over to Daniel from Epilogue Wills, who is going to show one of the ways that you can get your wills done with the service that is provided through Epilogue Wills. So, as I'd mentioned in kind of leading up to this session, there's a lot of things that we do online these days. And this is one of the other things that's now available. And then the final part of this session is that, after we bid farewell to our panelists, I usually stay around for a few minutes for an Ask Me Anything session, which could be related tonight, could be related to other areas of wealth management that I assist people with, from investments, tax strategies, anything related to personal finance. Now, if you are joining us for the first time, my name is Orlando. I am an investment advisor and a financial planner at RBC Dominion Securities. This month actually makes 3 years since I've been with RBC. I was at a previous firm for over 11 years. So I've been in the industry for some time. And while working in industry, there's also a period that I taught finance part-time at York University, my alma mater. And it's something that personal finance, teaching, educating, it's something that I'm passionate about. So I get to sort of scratch that itch by doing these webinars, except I don't get to give out any exams. That's the only part that I miss. But anyways, now as an advisor, I do work with individuals. I work with families in navigating various stages of their financial and life journey. Some are, pre-retires, some are already in retirement. And I do that with my own knowledge as well as the expertise of a number of colleagues and individuals in my firm and in the industry in general. And I'm happy that you are joining us tonight, and hopefully it won't be your last time. So with the holiday, the season coming up, we're getting close to the festivities, and usually there's a lot of shopping that starts to take place. And some of you may have had the experience of buying something online. How about online dating? It's actually in 2022. It's a bit odd, a bit weird these days when a new couple tells me that they didn't meet online. Usually the conversation is like, like you didn't meet online, you met in person, as in like face to face, like the real world. That's interesting, nice. But you get my point. There's a lot of things that we've evolved and are now doing online more and more. That's become normalized, and this is just one of the things that, again, is a bit new, but wanted to sort of bring the exposure to individuals joining us. And I'm curious to find out from those attending about some of your own experience with online. And usually what I'll do is we'll do a Slido poll. So if you've got your phone handy, or you can just go to slido.com. We're going to ask you a few quick questions. So go to slido.com and input that number 255-4714. And we're going to do a very quick poll. So I'm going to move on to the first question. Okay, here we go. Wonderful. I went too fast. Here's question number 1. Have you ever done online shopping? That is question number 1. So on the left, you'll still see that number 255-4714, or just scan the QR code and that will take you to it as well. So I'll give it a bit more. Okay, everybody 100% so far. Give it a little bit more. And this one is a landslide. Right. Okay, so everybody at least done some form of online shopping. Should not be surprised. Next question, do you currently have an up-to-date will? Yes or no, do you have an up-to-date will? So leaning more towards, give it a little bit more time. Okay, and then the final, what's the main barrier to you getting your will done? What has been, even for those who do have a will, maybe what was the barrier that you faced prior to getting your will done? Is it cost, enough information about it, or the time and convenience? Time and convenience is the biggest one. Okay. Well, that will be helpful for our panelists. I appreciate you taking time to sort of vote in that poll. And without further ado, I'm going to introduce you to our panelists, starting with Leslie. Leslie Donsky, always a good resource in terms of her wealth of knowledge as it relates to the practice of will and estate. She's got experience working for a previous law firm, and I do want to make sure, I really need to highlight that, Leslie is no fly-by-night lawyer. She actually, and I'm giving her a bit of a shout out, was recently awarded Young Practitioner of the Year award. Now, and it's not the Young Practitioner in Toronto, not in Ontario, not in Canada. This is, I'm just sharing that website here. You'll notice this is from the, trust and estate practitioners. There's a lot of, this is global. So you're seeing firms here and individuals that are not just Canadian, right? So there's different categories. And she was, I think probably in this category, probably the only Canadian. So I definitely want to, give her that shout out, let you know that we are very privileged. We're very fortunate to have Leslie with us to share her knowledge. So Leslie, I'm gonna pull up your slides, and thank you for always being so generous with your time and your knowledge.
Thank you for having me. Firstly, for those of you who have attended some of Orlando's webinars before, I'm often the highlight feature for November because, as he mentioned, November is Make a Will Month. So if you ask me or any estate lawyer, we would say every month should be Make a Will Month, but November is the official one. What we've learned recently is that 52% of Canadians still don't have a will. So the attendees on this seminar are actually batting above average, 63%, which I'm happy to hear. That's great. But in our data, we found that 25% of Canadians don't know where to start with creating their will. So that's a barrier. And that is what Orlando with these webinars is trying to do. Let's have a conversation and talk about how we can create a will and what that might look like for you. Daniel will get into this in his part of the presentation, but recently Royal Trust has partnered with Epilogue Wills to try and catch this 52% of Canadians that fall into the category of not having a will, and seeing how we can, broaden the area of those who need it. I'm just waiting for you to, there we go. So I just wanted to briefly touch on what is an estate plan. Today, we're mainly going to focus on the will, but we'd be remiss not to touch on everything. In an estate plan, the two main components are a will and a power of attorney for property, which is, a will basically while you're still alive. So it's what would happen to you in the event of incapacity, who would manage your assets, who would manage your personal care, all of those types of decisions. But there are other components to consider in the general estate plan. This is probate planning, income tax planning, life insurance designations, family law. You'll see that all of those are demonstrated around this spider's web that is shown to you right now. The reason we use a spider web graphic is because you can't touch one part of the estate plan without affecting everything else that's involved. But again, you'll see our two main pillars are that will and power of attorney, but everything else is an important consideration when you're making your will plan. What I wanted to talk to you about before we get into the epilogue side of the conversation is what it means to be an executor. Because anybody making a will is going to need to appoint someone as an executor. The overall responsibility of the executor is to administer the estate according to the deceased's final wishes as expressed in the will and according to provincial law. In certain cases, if you don't have a will, if you don't have an alternate will, an executor can be named by the courts. So an executor can be anybody. It could be a family member, it could be a trust company like Royal Trust where I work, it could be an accountant, it could be a lawyer, but you need to have one. And there are a lot of considerations that are involved in deciding who might be a good fit for your executor. In regard to what is required of an executor, there are 70 odd tasks, and administering an estate can take anywhere from 18 to 20 months, depending on probate and what's involved. And so it really isn't a light ask of somebody. It's a lot to ask of them, and it can put a really big burden on whomever you're asking to be executor. And so it's really important that you're considering this when you're creating your will, because you're going to need somebody to be in that role for you. So as I mentioned, the executor has a lot of duties and obligations. So they have an obligation to the beneficiaries, who are going to be the ones receiving your estate. They have, their own family and work obligations on the side. They also have to deal with a lawyer, accountant, the government, realtors if there's property, the CRA, investment advisors, banks. There's a lot of moving pieces. And they also are basically a business partner. They have to coordinate and quarterback everything. And so when acting as an executor, we break it down into 7 categories or 7 stages. First, there's preliminary steps. So executors will be involved from the beginning. They'll help with funeral arrangements. They'll help with the probate process, which is the process of validating that it's your last will and testament. They'll deal with the probate taxes. They'll also deal with the beneficiaries and their relationships. So you want to make sure whoever you're choosing as an executor has a good relationship with these beneficiaries, because they're going to be talking a lot. When someone like Royal Trust is appointed, of course, we'll always make sure that there's an open line of communications, expectations are set, you know, that's the standard. The executor also has to safeguard estate assets. So you want to take out insurance if there's, you know, a vacant home. You got to be in charge of real estate, all the content, everything like that. You're responsible for valuing the estate. So looking at stocks, looking at bonds, gathering any benefits that might be payable, anything like that. You have to administer the estate, which is the process of, again, seeing what there is, how we can distribute it, seeing if we need to rejig any investments, anything like that. You have to deal with the final taxes, so any outstanding tax returns, a terminal tax return, and then finally, after all of that is when you can distribute the estate. So just getting to that point, you know, I feel like I've been talking about it for 3 minutes already. There's so much to do. And so oftentimes it's a big burden to put on an individual, a family member, a young child. So it's something that's very important to consider when you're planning your estate. So you might be wondering then what makes a good executor. So among other considerations, your executor should be someone who is trustworthy and diplomatic, preferably resides within the province, is available and willing, which is a big one, financially savvy, and likely to survive you. So among those considerations, you know, you want to make sure that it's someone who potentially won't be involved in family conflict, somebody who, you know, again, can make decisions on your behalf without causing any strife within the family, without offending anybody. There's a lot of moving parts. And so Royal Trust, where I work, we offer what's called a corporate executor service. And this is where a trust company can act as executor for you. It's a third party who can get involved and just offers you that peace of mind that you don't have to burden any of your loved ones with any problems. So again, you know, you don't have to have a jurisdictional issue. You don't have to have a blended family. You don't have to have a complex estate. It's a good consideration for anybody depending on the circumstances.
Right. And every time you mention all of the different tasks involved, it does make my head spin. There's a lot of moving pieces. And the, you know, that web, I always like that because it really captures and kind of breaks down what individuals usually go to first, which is the will, which is important. And that's what we want to get to next, which is getting a will done, but now with the benefit of technology and RBC's collaboration with Epilogue. So Danielle, thank you for joining. We've been having this conversation for quite some time, maybe even more than beyond a year. And, you know, happy that we can finally sort of shed some light, not just conceptually, but to really allow individuals to sort of see, okay, how difficult or how easy it is to sort of get their will, or that process started.
Absolutely. Thank you so much for having me. So hi, everybody. Thanks for attending. My name is Daniel Golgut. I am one of the co-founders and the CEO of Epilogue. Prior to starting Epilogue, I was a lawyer practicing in Toronto doing corporate tax and estate planning work. So I saw firsthand the struggle that people have with getting their estate planning documents completed. You know, the poll that Orlando put up earlier is pretty accurate. I know that this is a very small sample size that we're looking at, but time and convenience is one of those things that people would often say. Cost is another one. And in terms of the number of people who have their wills done versus those that don't, so the stats that Leslie was mentioning earlier, so about 52% of Canadian adults don't have a will at all. And then there's another 15% or so who have a will that they say isn't up to date. And so I think the number that we had on the screen of no will was sort of 63% or something like that, which is interesting because that actually reflects the Canadian population in terms of those that don't have an up-to-date will. So as I mentioned, I left private practice to start a company called Epilogue to make estate planning easier, more affordable, more approachable. And so when I was speaking with Orlando, what he thought would be a good way to use our time today is for me to actually walk through the process of creating a will using Epilogue. And I think that's a good way for me to sort of open people's eyes to what the process actually looks like, what it feels like, the type of questions that you can expect to see, the type of decisions you'll be expected to make as you navigate the process. So if anyone has any questions while I'm going through, Orlando, I'm not sure if they come to you or to me or to both of us, but people can feel free to just ask them when they have them. Sometimes that's sort of better and more helpful to everyone who's listening than waiting to the end. So as long as there's a way for people to do that, I'm open to it.
Yeah.
I encourage it. That works. And so let's just jump in. So what you're looking at right now on your screen is the Epilogue Wills website. So someone who navigates to this website can click any of the Start My Will buttons, and that will sort of bring them into the world of creating their will. So here we are. So today what I'm going to do is, and this was something that I chatted with Orlando about, is I'm going to make Homer Simpson's will going through. And so I think that's a useful way for people to understand sort of who the people are involved, what are the decisions that get made. I'm going to start right from the beginning. I'm going to go all the way through to the end. So this is the exact experience that someone would have if they were going through the process for the first time. So let's get into it. So Epilogue is currently available in 9 Canadian provinces. So those are the provinces that are listed here. So if you live in one of those provinces, you can sort of answer like that and then continue through. Do you have a spouse or a partner? So in Homer's case, that answer is yes. And I'll go through some of the sections sort of rather quickly, just to make sure that we've got enough time to get all the way to the end. So do you have any children? The answer to that is also yes. This is the first threshold question that we ask in the process. So we know that online wills are not right for everyone, and that's so an important feature of how we built the product is to make sure we ask certain questions to find out if we think that an online will is right for the person that's coming through. So if someone does have children with anyone other than their current spouse or partner, we think that's a situation where you are better off speaking to a lawyer to get specific advice about your situation. So for the purpose of continuing through the flow, I will answer no. And also, as far as I know, Homer doesn't have children with anyone. This is the next threshold question. So does anyone in your immediate family receive government disability benefits under the Ontario Disability Support Program? So for someone who answers yes, it's the same thing. We think that person would be better served by speaking with a lawyer to include a Henson trust in their will. That's not something that we are currently doing. And so that's what we message to those people. If that is not the circumstance that someone is in, they can answer no and continue through. One of the decisions that we made early on is that for someone who has a spouse and kids, the default distribution for that person is going to leave everything to their current spouse, other than charitable gifts or gifts of personal property. And if the spouse has predeceased, it's going to go equally to the children. So for someone who comes through who has no spouse and no kids, that person is going to have total flexibility in terms of the distribution of their assets. But someone who comes in this situation, we've limited what they can do in some way. The reason that we did that is we think that wills that exclude spouses or that leave things unevenly between children, those are wills that are more likely to be challenged. In our view, those are riskier wills. And because we don't have the benefit of speaking to everyone who comes through the system, we can't determine sort of what that level of risk is. So for someone who's in that situation, who wants to do that, to exclude an immediate family member from their will, it's not to say that they can't do it. We just think they shouldn't do it using Epilogue. So if that looks fine for someone, they'll click continue and go on through. They will create an account. So we will do okay. Now that the account is created, anyone who comes through, as soon as you create an account, everything from thereafter will be saved. So that you don't have to complete the entire process in one sitting. From this point, you can just log back in with those credentials, and anything that you've done sort of up to that point and beyond will all be saved. So let's continue through. So this question here says a will deals with what happens after someone dies, which is what Leslie mentioned earlier, but there's incapacity planning documents that people often do as well. So in Ontario, there's a power of attorney for property and a power of attorney for personal care. So with Epilogue, someone can choose to do only a will or a will and the incapacity documents. I'll choose only a will just in the interest of time to make sure that we get through to the end of the process. But I'll say it's most common for people that come through and use Epilogue to do all of the documents. Okay, so we're on our way now. You can see at the top, it breaks out into 5 sections. So basics, family, guardians, distribution, and executor. So in the basic section, we're just gathering basic information about the individual. So in this case, it's Homer. I think there's a middle initial, J. Simpson. If someone happens to sort of commonly use a name other than their given name, they have an opportunity here to include that, which will go in the will. Marital status, date of birth, where in Ontario do you live? What gender do you identify with? So there's a few places throughout the document where pronouns are used, and the only reason that we ask that question is to make sure that we use the pronouns that people would use to identify themselves. Do you have any pets? Yes. Do you have any RESPs in place? And we'll say yes. Do you own any real estate outside of Canada? So this is not a threshold question in the way that the earlier ones were, but it's meant to identify if someone does. We just want to let them know that because they live in Ontario, they'll likely need a Canadian will to deal with their Canadian assets. It might be the case that they also want to consider whether they need a will in the other jurisdiction. So here we'll say no. So at the end of every section, there's a summary. So that goes through all the questions and answers up to this point. And someone can make sure that they've given sort of the right answers and look through and make sure that they've spelled everything correctly. Everything looks good. You continue on. Next section now is the family section. So spouse's name. How would you like your spouse referred to? So this is just a matter of personal preference if people choose one. Gender identity. So here we message that every adult needs their own will. So with Epilogue, if you would like us to help your spouse create a will too, you'll say yes, give us their email address. And then after spouse 1 finishes the process, an email will go directly to spouse 2 and give them an opportunity to create their own account. And that way each person has a separate account and they can make updates to their documents independently. So for the purpose of this, we'll say no. And so next is info about your kids. So it's just name and date of birth. The reason that we ask for date of birth here is so we know whether a guardianship question should be asked later in the flow. So you start with the first child.
I'm curious to see whose home we're going to choose as executor, Bart or Lisa.
I think he's going to choose Royal Trust, but we will. But we'll get there. So I'm just choosing birthdays here that make the kids minors. If someone has a stepchild who is not legally adopted, they have the option to click this box here so that we know, so that we can ask that question later on. By law in Ontario, a stepchild is not considered a child for the purposes of distribution of the estate unless they've been specifically included. And so that's why it's important for us to know that and important for us to message that later in the process. Okay. Pets. So we have, I believe, Santa's little helper, who is a dog. We will add Snowball, who's a cat. I think there may be others. I checked the Wikipedia page before, but it's not worth going through and naming them all. So we've got 2 there. That's what's important. And then the same thing, a summary section here to go through all the information that was given. That looks good. We continue on. So now guardianship. So in this case, because I answered earlier questions that I have minor children and pets, that's why I'm seeing a guardianship section. If I was someone who only had adult children, and no pets, I would not have to answer any questions about guardianship. So now we continue on. So who should be the guardian of minor children? So let's go with Patty. I haven't watched the show in a long time, and I don't know whether she would be an appropriate guardian, but that's what we will go with for now. Save and continue. And then you'll also be asked for an alternate guardian. So in each case, you're asked for an original and an alternate. It's optional to name the alternate, but in many cases that would be a good idea. And then you choose the relationship as well. Save and continue. Here you can name someone to look after pets if you're not alive. So we can go with Barney as the pet guardian. He's a friend. Save and continue. In this case, I won't choose an alternate pet guardian, and we'll just continue through. So that's it for the guardianship section. So an original and an alternate, and an original and an alternate if you choose to name them, and then continue through. So, I mean, I should say, you know, you saw I went through that rather quickly. That's one of those things that people can struggle with, deciding who the right person is to be their guardian. I mean, when you have minor children, that is a major reason that people go to make wills, and then they get to that section, whether this is in conversation with a lawyer or using a service, and then it's something that makes people pause and have some discussion around. So that's one of the biggest decisions you'll make here. Which is why when you use a program like Epilog, you don't need to do it all in one sitting. And so if that's a place where you stop and say, you know, me and my spouse need to have a conversation about this, of course, you can do that and then return later when you know what you want to do. Okay, so now we're into the distribution section. So as I mentioned before, the default distribution here is that your spouse will inherit all of your money, property, and other assets if they're alive at the time that you die. If your spouse predeceases, then everything will be split equally between your children. So one thing I maybe should have mentioned earlier, but there's this help modal up here. And so if someone has is looking for information from sort of in some of the questions that they answer, this is a place that they can go, and there'll be some questions that have a lot of information because they're more common that people have questions about. But it's something that is sort of always there and available. Some people like to make donations in their will to support charities. Is this something that you'd like to do? So we'll say yes. Here you can input the charity name. So someone can start typing a charity's name. You can see that it's searching as the person does that. So we have all of the registered charities in Canada in our database. And when someone starts searching, the idea here is that you start typing, find the charity you're looking for, and then click it. And that allows us to include the correct legal name of the charity, the registration number, and the location of the head office. Then you can choose here to make a dollar amount gift or a percentage gift. In this case, we'll do a dollar amount. Save and continue. If Marge dies before you, at what age should your kids get control over their inheritance? And then we message here, don't worry, money can be distributed earlier if your kids need some or all of it for things like education or living expenses. So the idea here is that every will that we create has a trust for issue provision, which means that there's a general trust, and any person who is under the age that you select in this answer is going to have that money managed for them by a trustee. And then the age that you select here is the age at which it must be distributed to them. So we'll choose 25 and carry on. The next question is what we would call the remote distribution. So if your spouse and all of your lineal descendants, so your children, grandchildren, great-grandchildren, if none of them are alive at the time that you pass, then who would you like to distribute your assets to? So you can choose individuals, you can choose charities. So in this case, first we'll do Patty. Then you can add an individual. And this message here says that if you are adding an individual, that the distribution is going to be done by portions or shares. And I'll show you how that works down here. So we've got Patty, who's getting one portion. Then I'm going to add Selma, who's going to get one portion as well. And when you scroll down, so that's 1 out of 2 portions. This is 1 out of 2. So each of them is getting 50%. If you adjust the portions, Now this is 2 out of a total of 3 portions, so she's getting 67%, and 1 out of a total of 3, so that's 33%. So we will leave it as that and just leave it 50-50. The next question asks if any of the people that you just named should die before you, what would you like to happen to their share? So you can choose to split it among their children, if they have any at the time of your death, or for that share just to be split among the others that you've named as beneficiaries. So we can, I don't know if they have children, but I will choose that option and leave it open. So the next question is about personal items. So are there any personal articles that you'd like to leave to someone specific? So if you say yes here, you can choose what those items are. So we will do my bowling ball. You can leave that to Bart. And then we will choose the relationship. So this person is my son. You can leave another gift. You can leave as many as you like, but we'll just leave it there for now. If you want, you can select a lump sum of money to be paid to a pet guardian. So the money is not being left to the pet. The money is being left to the pet guardian, which can either be used to help care for the pet or simply as a token of your appreciation. So you've got a sliding scale. You can choose any amount. And that's it for the distribution questions. So again, you can look through, make sure that this is all correct. All the names have been spelled the way you want them to, and that this all looks good to you, and then click continue. And now we're into the last section, which is naming an executor. So in this case, when someone has a spouse or partner, the question that they get is a question that asks if they want their spouse or partner to be their executor, to be responsible for managing their affairs and carrying out their wishes. So in this case, we will say yes. So this next question is something that is fairly new to our system. And this is the opportunity for someone who is using Epilogue to actually name a corporate executor. So name a professional trust company. So here, the options that are available are you can name a person to be Marge's co-executor. You can click here to learn more about appointing a trust company as co-executor, or you could decide that you don't want to appoint a co-executor at all. So we'll just go through this flow a little bit just to give people an idea of sort of what it would look like using Epilogue to name a corporate executor. So, I mean, as you can see here on the side, there's a lot of information. There's a lot of education that's available, including some video content from, this is Leanne Kaufman, who's the president and CEO of RBC Royal Trust. And this is an excellent 3-minute video that just talks about sort of what a professional trust company does and where it may be a good fit. There's information in here about fees, when they charge fees, all that kind of stuff. So a few important things that we mentioned to people here. So the first is that you don't need to be a client of RBC to appoint RBC Royal Trust. The second is Epilogue specific. I mean, we've worked with Royal Trust, and the decision was if someone names Royal Trust to be an executor under the will, they will have to name an alternate. So in other cases, it's optional to name an alternate, but here Royal Trust wants to make sure that there is an alternate in the event that they are unable or unwilling to act. And then finally, with respect to fees, so all executors are entitled to charge fees to the estate, and Royal Trust charges fees. Not all executors will charge fees. So if someone names their spouse, for example, and their spouse is getting everything from the estate, it's unlikely that their spouse is going to charge fees. If you name a friend, that's different because they may or may not be a beneficiary. If you name your spouse, even if they're not charging fees, they do have the ability to hire professionals to help in the administration of the estate. So that could be lawyers or accountants and stuff like that. But in any event, when you appoint Royal Trust, you are specifically agreeing to paying fees according to a fee agreement that you sign at the time that you make your will. So here, if someone sees all that and chooses to continue, they have an opportunity to see the fee agreement here, review it right on the site. They can scroll through. You'll see up here it says, I, Homer J. Simpson. So this is the actual fee agreement that someone is going to sign to agree to the fees. You can scroll through down here, read all of it. I have, so I won't spend time reading it here again. And then you're asked to initial in 4 places throughout, just to confirm that someone has gone through and read the document. Once someone has initialed in all 4 places, you'll see this bottom box goes yellow, and it says, by checking this box, I acknowledge that I've read the fee agreement, agreed to its terms, and wish to appoint RBC Royal Trust as co-executor of my will. And if you click that button there, then the date goes in, a stylized signature appears, and the printed name. You can click continue. There's discounts that are available for individuals who, when they pass, have accounts at RBC. And so that's a question that we ask here. So we will assume that Homer is a client. As I mentioned, then there's a question about alternate executor here. So we can go with Ned. So we asked earlier whether the person had RESPs, and so that allows us to then ask the question here, should your RESPs be maintained after your death? So RESPs are different from RRSPs and TFSAs. So with an RRSP or TFSA, you name a beneficiary, and so that money passes outside of your estate and goes directly to the beneficiaries that you've named. With an RESP, you don't name a beneficiary. The only way to make sure that some of those benefits are not lost is to name what's called a successor subscriber. And the only way to do that is to do it in a will. So that's why we ask that question here. And if someone says yes, then we'll include language in the will that names a successor subscriber. So this is the summary right here. So summary of the executor process, and you click continue, and that's it. So that's the entire process to get your will done. So it's the basics, basic information, family, guardianship, distribution, and executor. As I mentioned, I didn't choose to do powers of attorney this time, but that is the basic flow that people will go through. I'm not sure how long it took, maybe 15 minutes or so, 15, 20 minutes. And then you can generate your documents. We ask here how someone heard about us, but you can skip that. So a will in every province in Canada other than BC right now needs to be printed and signed. And so we offer a printing service where we'll print the documents and send them to someone. If you have your own printer and you'd like to print them yourselves, you can at no cost. So someone can choose that option. And then here's the payment screen. You go through, you can actually preview your documents right here. So you can preview, in this case, we only did a will. Orlando, you can still see that? Thumbs up?
Oh, yeah, yeah.
Okay. So here's the cover page. So this is the last will. And then we have here the last will of Homer in the city and in the province. Here's the guardian for minor children provision. So in this case, it's Patty. And if Patty's unable, it goes to Selma. Appointment of executors. So my wife, Marge, and Royal Trust. If Marge or Royal Trust is unable to act, it goes to Ned. And then you can see down here in the bottom, we've got a space to initial. So Homer, witness 1, witness 2. So that's covered in the signing instructions that come in the final document. The pets provision here. So this is the pet guardian, and this is the lump sum amount that will go to the pet guardian. The charitable gifts that we've included. So the name of the charity with the registration number, specific gifts. So this is the bowling ball to Bart. And then this is all other personal articles which go to Marge. And the residue provision. So I won't go all the way through everything, but someone can get a pretty good look at the document that they've created before they pay. And then after someone pays on Epilogue, they can come back and make unlimited updates for free in the future. So if in 2 months or 2 years, you decide you want to name someone else as your executor or guardian, or now you want to leave a charitable gift and you didn't before, or there's now a piece of jewelry or art that you would like to leave to someone specific, you can come through and make those changes.
Nice and smooth.
So I'm going to stop sharing there.
Yeah, and good on Homer for getting his house in order.
That's right.
So I'll open it up for questions. I mean, I think um, yeah, it was really clear to me in terms of how to someone can walk through it. And if anybody has a question for Leslie or Dan, just use the raise hand feature. I'm going to share um, the screen just so you can see what that looks like. And as soon as I see it, I will unmute you so that you can ask your question. There we go. Oh, I need to take control. Okay, so we got a question from.
For sure. I'm happy to jump in. So it's a great question. So generally speaking, an inventory of your assets is not included in your will. And there's a few different reasons for that. One of those is that people's assets change fairly frequently. And if you were updating your will every time your assets changed, it would be sort of unwieldy. The other thing is a will can become a public document after it goes through probate. And so listing out sort of each asset that someone owns in the will is just not um, sort of not best practice, I would say. Having said that, it can be really valuable for family and for your executor to understand what assets you have. And so it's common for people to create a document that sits outside of their will. It can be a simple Microsoft Word document, which someone can create to be an inventory of their assets. So it can go through and say, accounts, so where do I bank? What financial institutions, including information about sort of maybe key contacts. So who's the person that I deal with at that institution, maybe account numbers and values, as long as it's being kept somewhere safe. Cars, real estate, art, anything that someone wants to go through. I mean, you can get into enough as much detail as what are my monthly bills? Like, what are my recurring payments that are coming out? So that's all really good stuff to have. I mean, given the number of people without wills, I would say even the people with wills, it's a smaller sort of group that are that prepared and go to that level of detail. But it's absolutely something that would be valuable, whether it's an individual or a professional trust company that was acting. And that's one of those things that on a yearly basis, you could go in and update. So if you switched banks, you can update that document and have it with your will. You don't need to go through the same process of updating your will and getting witness signatures and going through all of that.
Okay. Thank
Okay,
you.
question, Alicia.
Yep.
And let me see if there's any other question I was just sharing. That is what the raise hand feature looks like. And let me just take a quick again. Sec. Okay, I think that might be it for questions. I mean, it seemed really smooth. You really went right on time at 7:45. I think those are some of the things, even that question that Leisha asked about inventory, and I think that might be a hurdle for some individuals sometimes in thinking, okay, I need to go through and decide who gets each item, who gets a bowling ball, who gets this. While it might be when you do um, portions or percentages, that allows for it to be a little bit easier. Maybe there's a few exceptions that you want to be specific about, and then the majority is, well, the value of that estate gets divided by a certain proportion. So for my conversations, that's one thing people struggle with, as well as maybe who to name, as you mentioned, as a guardian, but sometimes who to pass things on to. So, I think at least this option solves one problem, the convenience piece, the time piece. Unfortunately, we can't help with the other things in terms of who do you designate for, guardians and beneficiaries. So that just takes a lots of cups of teas and coffee and just some deep thinking and reflection to solve that one, right? And let me just see, I think Leisure's hand is just still up from the previous one. Still have a couple of persons on the call. Does that mean it was pretty clear and straightforward and you know, not much, you know, on top of what Daniel mentioned? So his explanation was as clear cut. And also keep in mind that I think that part was helpful, Daniel, on the right hand side where you can sort of get more information about the different nuances or the definition for certain terms. We do have one other question. Good question. And you know, sometimes this is the biggest hurdle, the conversation with family around it, which can be an awkward one. I mean, something I think helps is not being 100% direct. So you could open a conversation maybe in relation to someone that you both know mutually, right? If there is somebody that your mom knows, a cousin, a family friend who has dealt with or is dealing with the passing of a family member and the estate, that could be something where you could get her to start sharing what her thoughts are on what that family member is going through. You could also, what I've suggested some people to is, you know, webinar like this, sometimes you can get a family member to join to watch the webinar, watch the recording, to sort of get their thoughts on the topic, right? Another thing that sometimes helps is, would it be easier for that message to come from another party, another trusted family member or close friend that you know, they'll receive the message in a different way versus it coming from, well, you know, you're my daughter, I'm your mom, I know more than you, you know, who are you to tell me what to do, or stuff like that. So kind of almost getting advocates or somebody else to help with that conversation. And you know, it doesn't happen overnight, right? I've seen that myself. It does take some persistence. So those are a few things I would sort of I could share. I don't know if Dan or Leslie have anything else from your experience in terms of, you know, approaching that conversation, which can be awkward for across generations.
Yeah, I mean, I think it certainly can be, and it really depends a lot on sort of the nature of the relationship. I think Orlando's advice is good advice. Some people's fear comes from a place that if they talk about money, it will seem like that is the reason that they're bringing it up because they're wondering about inheritance or how much or things like that. So I think sort of Orlando's advice to maybe sort of stay away from that as sort of the driving topic, and more around preparedness, and understanding. I think that's important. Um, yeah, but it's certainly challenging. I think that also not necessarily feeling like you need to have the entire conversation at once. And so if you can approach the topic um, somehow in a way that might be more comfortable in that sort of a smaller conversation, just to bring it up and then to circle back on it and sort of gauge sort of openness to having it. Like you may end up being surprised that there is an openness to having the conversation, or you may find out that, there's still a lot of reservation about it and there's more work to do just in terms of opening up the discussion. So start small and then get a read on how things are going and where to go from there.
And I've got one more question, but I'll add one other thing. I had actually opened up a conversation with my granddad when I shared with him that, you know, oh, I just got my will done, just a couple of years ago. You know, by the way, have you done your will? So that also was one, you know, the way I did it, and it sort of, you know, was an implied thing in terms of, well, if I'm this young and I'm getting my will done, well, you know, it's not an age thing. It's not because I'm saying that, well, you're old, you should go get your will done kind of thing. It's just something that is important to do, and I wanted to share that experience with him, and then that kind of got the conversation going. I had to bring my uncle also into it. It took yeah, a year or two before we eventually got over that bridge. And yeah, so having that extra person as well was helpful in my case.
Sure, absolutely. And it's a great question. So in Canada, in every province other than British Columbia, a will still needs to be printed and signed by hand, no electronic signatures. So when you finish the process, if you used Epilogue to do your will, you would get the document along with a set of signing instructions. And those signing instructions would tell you step by step what you need to do. So if the document has not been printed by us, you need to print it, staple it together, remove certain pages, review it to make sure that everything looks the way that you want it to look. If it does, find two witnesses, and there's some explanation about who should not be witnesses. So anyone who stands to benefit from your will, so a spouse or children, if they're beneficiaries under the will, they should not be witnesses. Their family members should also not be witnesses. So if you've got an adult child who's married and who has kids, they are also not good candidates to become witnesses of your will. So people often find friends or colleagues or neighbors, people like that to serve in that role. Again, in every province, I'll sort of not speak about BC here, but I'll speak about rest of Canada. You need to meet with your witnesses in person. So it's two witnesses. You meet with them in person. You sign your will. So on the last page of the will, there's a place for your signature. You will sign the will. You'll initial every page, and then your witnesses will also sign, and there's dedicated spaces for them to sign and to initial as well. With Epilogue, you'll have to include the date that it's being signed. So that's mentioned in the signing instructions. All of these steps are mentioned there, but you'll include the date, then you'll sign, they will watch you sign, then they will sign. Once that full process is done, your will is legally binding. In certain provinces, so in Ontario, for example, there is an additional document called an affidavit of execution. So that document is not required in order to make your will valid. It can be helpful. So we include it with our package. That's a document that one of your witnesses would sign after they've witnessed you sign your will. And again, all of this is in the instructions. So they would take that and sign that in the presence of a notary or a commissioner. And that document basically says, I was there and I witnessed this person sign their will. Me and another witness were there and watched this person sign their will. And that's something that would stay with the will. A few more things that the will does not get sent anywhere. It doesn't get sent back to us. It doesn't get sent to anyone else. You keep the will. There can only be one original. So don't print out multiple copies and sign multiple copies because only one will can be valid. So if you did that, or if someone did that, it's only the last one that's valid. It's not all of them. So there's only one original. You keep that wherever you keep your important information, important documents. A safety deposit box is generally not a good place to keep a will. It's very hard for loved ones to get access. And I feel like there are less and less safety deposit boxes now anyways, but if you happen to have one, it's just not a great place because it's hard for people to get access to it. The advice is generally to keep it someplace that's fireproof and waterproof. That can be difficult depending on where people live and sort of the access that they have to a location that's fireproof and waterproof. But don't keep it on the ground because there's potential for water damage or stuff like that. Keep it someplace safe. I'll just say quickly, there is, depending on the province where you are, so BC has a will registry. So after you create your will, there's an agency that you register your will with. The rest of Canada does not have a province-run will registry. There's a private will registry called the Canada Will Registry. Even there, you do not send your documents to them. You just register the existence of your will. And so you record the date that it was created and where it's being stored. But ultimately, you will always keep the document. You should notify family and friends that you've created it. So the person that you've named as your executor or people that you trust, let them know that it's been created and where it's being stored so that in the event they need to find it, they know where to find it. That was a lot.
Yeah.
If you want to follow up with me, you're certainly welcome to. And like I said, if you use Epilogue, all of those instructions are laid out step by step. And there's signing instructions for the will, and there's separate signing instructions for the powers of attorney. They're similar in terms of the procedure that you follow, but each one of those documents comes with a set of signing instructions.
And then it sounds like it's in an ideal situation, you're meeting with the two witnesses at the same time. Is
You
that
must.
you must? Okay.
Yeah.
Got you.
Because the witness is witnessing, they're witnessing you and they're witnessing each other.
Each other. Yeah. Okay.
Yeah.
Yeah. Good, good, good. All right. I those are two really good questions. And at this time, I am just gonna pull up what we have left for the remainder of the year. So just one more webinar left, which is going to be in December 7th. I'm really looking forward to that one. We actually have an author who's written 3 books on retirement. So Mike Drack is a Canadian author, and I'm just going to pull up here real quick. So these are some of the books that he's written. Victory Lap, Retirement, Heaven or Hell, and then this is the most recent one that just came out in September that he's just written, Longevity Lifestyle by Design. I'm actually reading this right now, and he's going to be on that webinar along with our retirement coach, Jennifer, and that's something that I think is a role that's not so commonly heard about on this side of the border. It's somebody who helps with all the non-financial aspects of retirement. So not the non-technical pieces, that transition from that, that stage of work to then maybe work optional. And one of the things that's also good about this webinar, Mike has been generous that everyone that will be attending the webinar, he's offering a PDF version of his book for free so that people can read the book before the webinar. And there's a bit of a workbook workbook as well to help people. So I think it's good for anyone who is recently retired, is retired, or even is not retired. There's a lot of good stuff that I've been getting as I've been reading on some of my commutes downtown. I've just been reading on the subway. So that will be the next one for December 7th, and then that's it for the year. And then in 2023, mega trends, that's something in collaboration with RBC Global Asset Management and iShares. So just some of the different trends that are evolving, and if you can think about huge trends that took place in the last century. So going from horse-drawn buggies to motor vehicles, how long did it take for most Americans or North Americans to have a television? So there's these periods of time where we went through these transition. These time periods are shrinking. Like, when the iPhone came out, how long did it take from the initial launch till most people having access to one? So there's a lot of things taking place that are happening, which are also investment opportunities. So that's the focus on it. And then in February, retirement elsewhere, U.S. Sunbelting, bit of a repeat of what we did early this year, retirement elsewhere, when we looked at Belize and Costa Rica. This time we're going to just focus on the U.S., so Florida particularly, and just other U.S. Sunbelt. And then in March, Women Wired to Invest around International Women's Month. So that's kind of what is to come. And as always, the information will be there. Not always up yet where you can RSVP, but they will be there soon. And I think that is the majority. I'm always available to have a conversation with anyone about just the strategy that they're using, offer a second opinion, and either I can help you directly or indirectly through the colleagues and the relationships that I have in the industry. Continue to attend the webinars, invite others. It's just a way to continue to close that awareness gap, become more informed about the different options and strategies, because finance does evolve. It's not static, just like technology, just like it's another tool that does evolve over time. And I think it's easier to kind of grasp it in bite-sized pieces versus sort of saying, okay, I'm gonna use the holiday or my time off to just sort of digest a whole bunch of financial literature and then apply it. This way, it's sort of like gradual. And as always, most if it's on LinkedIn, you can invite others that way, or just forward the email link to these different webinars. Focus on my sessions is education, empowerment, and execution. So today was really focused on the execution part, right? So we try to go beyond just sort of saying, do your will, do your wills, go do your wills. This was a way to sort of really show how it can be executed, how hard or how simple, right? That's you can sort of, after seeing that actual, sort of walkthrough, how difficult would it be for you to do it on your own? And that's really the hope, because I think you can write a prescription, but does the prescription get filled, right? It's really important for people to have wills for their loved ones. It makes things easier for professionals as well, as in terms of helping the loved ones and navigate these things. And that is pretty much it. This is just a wheel of the process I sort of go through when I'm helping families. One, just try to understand where they're at, what are the gaps in terms of their strategy, and then just gradually helping them to close some of these gaps and improve their finances incrementally. So with that, I will thank you, Daniel and Leslie, for your time, your knowledge, your expertise. And hopefully we'll have budged that needle in how many Canadians do not have a will in some way, shape, or form between now and the end of the year. There might be at least one or a couple of people who will be getting their wills done.